was just wondering, I have only one question. The question was also raised by you. Can a DPO be the grievance redressal officer, GRO?
Yeah.
Technically, I would like some clarity on that and your thoughts, sir, please, to start the session, please.
Yeah. See, the Act seems to actually define two roles, one of the DPO and another of the grievance redressal officer. Now, DPO, in a way, represents the data principles interest. He has to take care of the data principles interest. Okay. The grievance redressal officer can be more institution oriented, data fiduciary oriented. So it is possible that the two may have a slight different viewpoint on a dispute. So if the two are different, I think it will be better. But at the same time, if the data protection officer has the
Sir, you're on mute again.
Yes, sir, you are muted.
Okay. So what I was trying to say is that the data protection officer basically has an interest of protecting the interest of the data principal. The GRO, on the other hand, can be more company oriented. To that extent, it is better if the two roles are held by different people. And the GRO needs to be more proficient with the skills of mediation, leading to the ability to later on take it in the legal sense to the data protection things. Whereas the data protection officer may actually hold a more friendly attitude with the data principal and try to resolve his issues. So probably the correct answer to the question is that if we can afford to have different people, it is better to have different people. Since anyway, Information Technology Act requires one more GRO. And we cannot have one GRO for ITA 2000 and another GRO for DPDPA. You can have one GRO who knows the law. He can be from the compliance department or the legal department, while the DPO continues to the techno-legal person who handles the interest of the data principal. Maybe this will also justify the words used in the role definition that the DPO will answer questions from the data principles. Okay. And it does not say that he will be solely responsible for the resolution of the disputes. This was actually discussed in detail in our July 27 event also. If you go through that event, there is one panel discussion in which this was specifically discussed also. Okay. Now, today and tomorrow, in the last 2 days of this program, we would like to cover one aspect which we had not discussed earlier, which is DPDPA rules. And then we go into the DGPSI, the 3 or 4 different aspects of DGPSI. One is the DGPSI Principles, then DGPSI Lite version. Then we will go into DGPSI full version along with DTS, Data Trust Code. If we get some time in between, we will try to also discuss certain case studies. That is the agenda for today and tomorrow. I wanted to take this DPDPA rules so that it will also help us in a way revise our earlier discussions on DPDPA Act, which we discussed 2 weeks back. Okay, so I think it will help us. Now, for this discussion, I would like you to be aware that there is this dpdpa.in, which is the I think I will show that screen. So I'll share the screen and then show the particular page, because that will give you some indication of where to go next if you want to look at the information again. Okay. Or okay, fine. Yeah, are you able to see the screen now?
Yes, sir. Screen, it is
Yes, sir. It is visible,
yeah,
sir.
yes. This is rules. Yes,
Yeah,
sir.
we can see.
Okay. So
Okay.
this just wanted to show this DPDPA.in this thing, because this is one place where you will be able to get the act chapter by chapter. Then it will also show you the preamble and the notes on clauses, which are important for us to actually understand the legislative intention. Like in GDPR, you look at recitals. This notes on clauses and preamble will help us to understand a little better. Then it also has the old Sri Krishna Committee report, which is the basis for the law as it has evolved, PDPB 2018, 2019, 2021. Now we have the current DPDPA rules. Then as for the DPDP Act. Now, as far as the rules are concerned, sometime back, this version one of the rules was in vogue. Government did not push it through, but we in FDPPI conducted our July event based on this rule, so that the industry feedback could be provided to the ministry. Afterwards, some more changes were made. These rules had 20 rules and 7 schedules. Now, currently what we call as rules 2025 version has got 22 rules and 7 schedules. There is a link to this, which also provides all the 22 rules along with the schedules, 7 schedules, Part A and Part B of Schedule 1, and then Schedule 4 also has got Part A and Part B. So all this information, including the PDF version, if you are comfortable with PDF version, you can look at that. You will be finding in this particular place. I think I have tried to put it in a HTML format, basically to work as my notes. I'm comfortable with perusing this from time to time in this format. You can create your own format for that. Okay. So today we will go through these 22 rules along with the schedules. I have the slides where I have made some marks, but it is also possible for us to go through this website itself and understand the entire set of rules. I have shared with you today the entire 6.5 hours of discussion, or what we had in July 27, which was a very detailed analysis of the 22/7 rule, 20/7 rule, which was then prevailing. And I feel that you can take a lot of learning out of the discussions which happened at that time. Though you must remember that that set of rules is now over. Now we have the new set of rules. So don't get confused with the old version of the rules here, but the discussions could be helpful. That's why I shared that with you. Okay, now if we simply go through this particular set of rules, the very first rule is something which talks about the title of these rules and when it is likely to commence. What this says is that some of the rules, there is the rules except 3 to 15, which means that 1 to 2, and then except 21, 22, the rest of the rules, that is rules 1 and 2, then starting from 16 to 20, they are likely to come into force on a different day, whereas these four rules, 1, 2, and then 16, 17, 18, 19, and 20. Okay, those 6 rules are likely to come into existence immediately. So when we are talking of the Government of India notifying the rules, that notification immediately could bring in only about 6 rules. These 6 rules, of course, the rules 1 and 2 are about the title and then the definitions, which is not that important. Whereas 16, 17, 18, 19, 20 are related to the formation of the Data Protection Board. So government is likely to come up with the notification about what is required for constitution of the board, because the government has to set up a committee to select the chairperson. It has to select the number of members. So that part will be first undertaken. The balance, okay, which is 3 to 15 and then 21 and 22 will come into force on a different day, which the government may either announce now, or they may not announce the date at present and leave it for a future notification. Most of the corporate requirements will come when these rules 3 to 15 or 21 to 22 are notified, because that speaks about the notice, consent, data breach notification, all that will come at that time. So we have to see whether a separate date will be indicated right now, or they will take their own time. That is, after the Data Protection Board comes into existence, the Data Protection Board has to first put up a website for contacting the public. Whether the public is a data principal or a data fiduciary, there has to be a website, and only then rest of the things will fall in place. So therefore, the government may give first 3 months or so for setting up of the Data Protection Board, and the Data Protection Board at least opening its basic website as a contact point. Then the rest of the rules may be notified. In an earlier version of the rules, government had clearly stated a timeline saying that Data Protection Board will be set up within 3 months. Then something else like notice consent system will come into being after 6 months, something like that. This time they have not done like that. There is one part of the act where the government is not very vocal right now. There are 2 sections, section 33, which is the penalty clause, and section 44, which talks about amendments to the acts such as ITA 2000 and the Right to Information Act. These 2 sections are actually now not specifically mentioned when they will become effective. See, section 33 is very important because this 250 crores we are talking of can be imposed by the Data Protection Board only if section 33 is also notified. So unless the government makes one statement that other than what is mentioned in this particular notification, rest of the sections of DPDPA will come into existence from a particular date, we will continue to have doubts about when the penalties will become effective. You know, in many other countries, they introduced the law from a particular date. Penalties were actually applied sometimes 1 year from the date of implementation of the main law. So that 1 year was given for the companies to actually get into the compliance. So we may also do that. So there is a need for a separate announcement about section 33. Now, section 44 talks about replacement of section 43 capital A of Information Technology Act with the provisions of this act. Now, Section 43 capital A today provides for remedy to data principles when there is a failure of due diligence and reasonable security practices. Now, in the absence of operation of Section 33, one has to actually fall back on Section 43 capital A of Information Technology Act for looking at reasonable security practices. Therefore, I feel that Section 44 also has to be notified separately, saying that from such and such a day, Section 43 capital A will be replaced and this particular act will be in place. Otherwise, people today are confused whether Section 43 capital A is still applicable or not. As of now, I feel it is still applicable unless it is separately notified as in this act. It will continue to be applicable. If Section 43 and other acts of other sections of Information Technology Act is applicable today, it will continue to be applicable even after Section 44 is notified. There are many people who are fighting on Section 44, subsection 3, which is on the Right to Information Act. It is of no great consequence to companies because companies are anyway not subject to RTI Act. And what the government has changed is only to say that if in the disclosure of the right to information, any privacy is likely to be breached of any person, then that can be withheld by the information officer. Now, earlier also this provision was there, but earlier it said that the officer has to justify why he is withholding some information. Now, the need to justify is not specifically mentioned. Other than that, there is no difference between the earlier RTI and this, though people may feel that since there is no need to justify, people may actually refuse disclosure whenever any personal data is involved in the disclosure. Now, when we talk of personal data, there are two kinds of personal data which we handle in the right to information. That is, sometimes the personal information of the officials of the government are likely to be included in the disclosure. So one reason why people are worried about disclosure is that this may make people say take some other extra constitutional action against officials and they will be defamed and so on. Second is, while I'm disclosing the information about one required disclosure, I may also disclose the personal data of somebody else. For example, somebody may actually make a request to the government to give how does a particular rural health scheme has been working and how many beneficiaries have been there, of what age in the last 1 year. Now, the information officer may give a list of such beneficiaries, which may contain the names, age, and other details of many other people. So that could be a disclosure of the privacy of the various other people, and that is what may now be withheld. There was one Madhya Pradesh case where in an earlier a few years back, when RTI information asked about a primary health center scheme for say pregnant women or something like that, and the government released a list which had the expected date of say delivery or something like that with the name, address, age, etc., which was considered at that point of time was not a very correct way of disclosure of information. Now, it is that kind of information which the amendment now perhaps tries to prevent. We have heard of this kind of disclosure even in HIPAA in the earlier days. I remember in the case of HIPAA, when one person asked about a person whose diagnostic report had diagnosed cancer wrongly, and when that person actually raised an objection, the hospital released a list of all the people whose diagnosis was done and said only one or two of the hundreds of tests we have made has failed and try to justify their release, their mistake from the statistical point of view. But while doing so, they had released the names and addresses of all the other people who had undergone that cancer test. And some of them actually took complaints against the hospital saying that there was no need for release of my information, while it was actually in a court, okay, while they were defending their case in the court. So I think the section 44 objections should be seen in this particular light. Okay. So let us, as corporate officials, not worry too much about that. Rule 2 is about definitions, and this actually adopts whatever definitions are already there in the digital DPDPA. Earlier rule actually tried to give definitions separately, which was not required. So this is a correct way of approaching the rule definition. Now, I don't know whether you are able to see the new.
No, it still your website is showing.
Yeah,
So you have to share your PPT now.
Okay. Then I will go back to my PPT, but just there. Okay.
So one question.
Yeah.
This website is maintained by MeTi, or is it maintained by anyone other teams?
It's Navi sirs.
Navi sir, okay.
Yeah, it is Navi sirs.
Yeah.
Oh, okay, nice.
Okay.
Thanks.
So it's not the ministry's, you can say, authentic site, but
Yeah.
I try to actually update it to the extent possible. Okay.
Very nice, sir.
Okay. You have some similar these things for Information Technology Act also. Okay. Fine.
Oh, okay.
So section by section, this old designing of frames with the menu on the left side. Okay, these are all not considered the right way of designing websites, but it is a functional way of designing the website as far as I'm concerned. Okay, now, now this I said, so these are the list of rules. The list of rules now is, apart from this date of effect definitions, we have got consent and notice, consent manager, then processing by government, then data breach. We will selectively choose some of these rules and go into greater details. Okay, this I completed. Now definitions also over. Now rule number 3 is about the notice. Okay, important because this is where we start our compliance. What the rules say is that we are required to have an itemized description of personal data and specified purpose in the notice. Then it also says itemized services to be provided or to be given, along with communication links on how to withdraw the consent, how to exercise rights, and how to make complaint to the DPP, which means that every company has to create sub pages for these things and then give that link in the notice. Otherwise, the notice has to be for a specified purpose. For that specified purpose, there should be a description of what data is being collected and what is directly the itemized service which will be provided because you are providing a particular data. Yeah, Mahesh.
Yeah, sir, here when you say make complaint, so can it also be that we give them the grievance redressal link?
Yeah, apart from the that comes under the exercising of the rights itself. See, when you say exercising of the rights for information, data access request, correction, and the erasure, and then the grievance redressal, then the nomination. These 4 things come under the rights. Then this making of the complaint to the Data Protection Board, that link also has to be provided here. Okay.
Okay. Okay.
Then one thing which I am trying to suggest is, when the person wants to exercise the right later on, that later on maybe after 1 month, after 6 months, after 1 year, or whatever is that, then the question of identifying that person becomes the most important aspect of exercising that right. Therefore, we have to actually put the person on notice even today that the identity information provided by you today, okay, will be determining, will have to be provided when you seek any of your rights. Say otherwise, he will use some friend's email address today and then perhaps register. And then when he raises a complaint later on, or a grievance later on, he may use some other email address. And at that time, you may say that, I don't know who you are, because your identity does not match with the identity you provided at the time of the consent. So I feel that you should add a disclosure, something to this effect. The identity information provided by the data principle in the consent shall be required to be produced at the time of exercising any rights under the Act, failing which identity has to be re-established to the satisfaction of the company, which means that at that time you may ask him to undergo a KYC at his expense, if at all there is an expenditure. So this is something which you can think of. Any thoughts on that? Many of you have already worked on consent, and there are many software companies which are actually producing consent management software, and all of them should have remembered this kind of identity establishment, which is a future problem, but we have to address it today. Then rule 4 is regarding the consent, okay, particularly the consent manager. Now, there is part A and part B, which talk about the consent manager. Of course, when we go into the detailed discussion consent manager, it will take a lot of time. I will try to actually be brief now and later on address the questions later on. Now, consent taken directly is associated with the notice. The notice is to be given with the itemized list, etc. Then we have to collect the consent as a equivalent to a contract, which means that authentication has to be there. We have already discussed that. Now, if you are getting the consent from a consent manager, Rule 4 actually describes what will be the registration requirements of a consent manager and what are the obligations of a consent manager. So Schedule 1A talks about the requirements. 1B talks about in detail the other aspects of conditions and other things. Let us briefly see what it is. Now, registration means that the person who wants to register himself as a consent manager has to make an application to the board. Board means here Data Protection Board, and with certain requirements, which is mentioned here. And if they are satisfactory, then the board may grant him the accreditation, which means that all Tom, Dick, and Harry who produce softwares cannot call themselves as consent managers. Say, that is why I am always insisting that we should distinguish how we refer to this consent management software. We should say this is a consent management software. You cannot name that consent management software as a consent manager. Okay, because consent manager is today a legal word. It cannot be loosely applied. Only such organizations which are registered with the Data Protection Board under this particular rule and the corresponding Section 5 of the Act will be called consent manager. Similarly, when an organization asks his HR head to say that you be the consent manager for all our employees, that is not exactly the consent manager under courts. Okay, that is an internal consent. You can say a person who manages the consents within the organization. He is not the consent manager. A data fiduciary cannot appoint either an official employee or even his data processor and call him as a consent manager. Consent manager is not an agent of the data fiduciary. He is somebody who is appointed by the data principal So if somebody wants to establish a business as consent manager, he has to first go to the data principles and say, be my client. Then he has to also go to a data fiduciary and say, I am the consent manager. That actually happens automatically once he registers. It is not necessary that the consent manager has to go and beg a data fiduciary that you please provide for acceptance of consent of my customers. Once a consent manager is registered with the data protection board, I'm sure they will have a broadcasting feature in their website that so-and-so has been accredited as a data a consent manager. Like today, if you go to the CCA website, controller of the certifying authorities, you have a list of certified CAs, certifying authorities. Now, when CCA approves a particular CA, they don't actually broadcast, but there is a website, public website, which says that so-and-so has been licensed from such and such a day to such and such a day, or whatever is that. Similarly, in the case of this consent manager, the data protection board will accredit a consent manager on satisfaction of the requirements, and then the data fiduciaries all over India needs to take notice of that and make provision for receiving consents through that consent manager. Okay, so that is something which they need to remember. Now, what are the obligations of this consent manager? If you go through that in detail, first of all, it says that this consent manager has to have a technology platform which will enable the data principal to provide consent. And this should be an interoperable platform so that any data fiduciary should be able to make use of it. But the question remains that it is not mandatory that a data principal will have one consent manager, or a data principal will be forced to come only through the consent manager. Neither of the two is necessary. And even after a person becomes a client of a data of a consent manager, he can go directly to the data fiduciary and provide his consent separately. So the data fiduciary will have consent coming directly from the data principal, but he should make a provision to collect the consent from a consent manager. I have provided very detailed analysis of this consent manager even in the last 2-3 days back in navi.org. Kindly go through that, because I have a very strong feeling that the rules which are shown here do not reflect the legal requirements which are there in the Act. This is one area where the rules do not match with the Act, and the ministry is making a mistake. And I hope that ministry may even withdraw this particular part of this, because it doesn't make sense. Why it doesn't make sense? You please go through the details which I have given. That is the reason why I don't want to go much into the detail. But however, just to see what this particular rules intended to do is, one of the things it says is the consent manager shall ensure that the manner of making personal data happens without it being able to read the personal data. It means that the consent manager does not have visibility to what data it is transferring as a consent. So this is where I said that consent manager is like a blind man. He doesn't know what information is being transferred, but he's supposed to transfer the data which the data fiduciary wants, and later on keep a record of the consent for 7 years and produce it as and when required. I don't know what is the use of holding a log record for 7 years without knowing what is inside the log record, and also where the data principal might have already closed his service with the data fiduciary, and beyond that, why there is a need for holding of the data, not the data, holding of the consent by the consent manager. Yeah, somebody has some thoughts on this?
So does the law says 7 years, or is it the organizations can define, or the consent managers can define? How does it work?
The Act says consent has to be maintained as per the purpose. Okay.
Okay.
And where it is required to be maintained by any other law, like Information Technology Act wants a particular information to be there for 180 days and other things. So the data retention is based only on the basis of the purpose. And as soon as the purpose is over, it is supposed to be actually deleted unless it is required
Yes.
by other reason for which you need to document and keep it. Okay. Now, the consent is an intermediary who provides consent on behalf of a data principal to the data fiduciary. Okay, that is an event. Now, in this process, what the consent manager will do is let us say, his services can be invoked either by the data principal or by the data fiduciary. So let us say you have gone to Zomato, you are trying to become a member of Zomato. Okay. Now there is a consent form. Now Zomato will have to initiate a request for certain data. Normally, you fill up a particular privacy notice page, and there I will put my name, address, etc., and say submit, and that is how things will happen today. Now, after this system comes into being, I may be a data principal who will say, I will not give you the fill up all these things. I am too lazy. Please collect it from my consent manager. Like what we do today for many forms. Forms are filled automatically by Google, Facebook, and other things. But
yes,
are doing the same work, but they are not consent managers under the Act. Okay, but they are doing more or less similar things. Okay. Now, instead of that Google or something like that, there has to be a drop-down list of registered, approved, accredited consent managers. That is, the data fiduciary should know who are all the 2, 3, 5, 10 consent managers who have been registered with the Data Protection Board, and he should be prepared to show them there so that I, as a data principal, will just select one of my consent managers. And when I select that, it will be necessary for me to give my account ID with that particular consent manager. Otherwise, the data cannot be located. So I should give a drop-down, have a drop-down menu. And then in the drop-down menu, if I select some XYZ consent manager, in addition to that, it should ask what is your account number. In that consent manager, I have to fill up that. Okay. Once I do that, then this data fiduciary has to send a message to this consent manager saying that your client wants to submit this following information from your sources. Okay. What information is required has to be supplied by the data fiduciary. So the account, this particular consent manager receives the request for a list of data elements. And at that time, he is not having any visibility to this data according to what ministry expects this particular business. So one thing is consent manager should then ask for a permission to the data fiduciary, data principal, that so and so has asked me for this following information. Can I give it? Okay. Yes, which means that what this person would have automatically filled up in the form, now he is actually giving permission to this manager. Okay.
Correct.
Now, that information may not be available with the consent manager because the services which the data fiduciary is giving is something which is different from one data fiduciary to another data fiduciary. And the consent manager is only having the account information, the name, email address, and mobile of a particular person with a account number. That's all is the information he is having. He doesn't have the health information. He doesn't have the financial information, bank account number. All these things are not there with the consent manager. But the consent manager is expected to fetch that data from some other approved data fiduciary. You see the irony of this. That is a data principal, when he goes to the consent manager, opens the account, he has to also designate, you can collect this information from my bank, A, B, C, D, or something like that. Then this secondary data fiduciaries become the data suppliers to the primary data fiduciary, to which the consent manager acts as a broker. I don't know whether it's clear to you, but if you know, there is a system called account aggregator system in
Correct. Can I say like Google's or PhonePay's? They're also the account aggregators, right?
No, they are not registered account aggregators. Not all of them are registered account aggregators with RBI. Again,
Oh,
to
okay.
be an account aggregator, you need to register with RBI as a regulated entity. There are requirements like what are there here. Okay. Now, such regulators are today functioning to supply data to, say, mutual funds and brokers and others. And when you want to open an account with, say, Angel One, there you will use the services of an account aggregator. Okay. The account aggregator is today working on this principle of no visibility because he pulls the data from data suppliers. This account aggregator system has got one set of people called data suppliers, another set of people called data requesters. Okay. Then there is this account holder, the data principal. Okay. So the data principal in account aggregator system is trying to open an account with, say, Angel One. And at that time, Angel One says, I want to do KYC. Okay. I will say that you can collect the information from the account aggregator who already has this information. And therefore, that organization calls for the information from the account aggregator. There are about, I think, 14, 15 registered account aggregators. If you want, you go to sahamati.org, you will get the list of such people. Okay. And that account aggregator will collect the information from, say, your ICICI Bank, your HDFC Bank, and which obviously you have to only designate. That is, when you open an account with an account aggregator, you have to designate my information is available in A, B, C, D, E people. So whenever there is a request, you can look at these things. So when Angel One asks for information, which is of financial nature, bank account, etc., the account aggregator sends out a request to, say, ICICI Bank, where you have your account, and ICICI Bank sends the details to Angel One in an encrypted channel without the visibility of the account aggregator. Account aggregator will only know that I had sent a request to this ICICI Bank. ICICI Bank confirms that they have sent the information there. So this process of account aggregator works on a particular system where a request is raised by a company like Angel One to the data principal or the person who is trying to open an account with Angel One. At that time, this person says, go to my account aggregator, and then the Angel One goes to the account aggregator. Account aggregator pops out one message to the data principal saying that, can I give this information to Angel One? You should say yes. And then they will send a message to ICICI Bank. Then ICICI Bank may also send another information, request to the data principal that I have received a request from your account aggregator to supply information to Angel One. Are you giving me the permission? And then ICICI Bank will transfer the information to the Angel One in an encrypted channel, and RBI and everybody is happy that there is no visibility to this data. As far as the account aggregator is concerned, we are having a very secure architecture, DPDPA architecture, under which data is exchanged. Now, this system has been in place in India for some time now.
Yes.
And now ministry thinks that that system is good enough for the DPDPA. In fact, DPDPA is data empowerment architecture, okay, protection architecture. Now, that also calls this account aggregator by the word consent manager. Okay. In fact, the government should have avoided the use of consent manager in two different regulatory messages, but they have not done that. So now, whether this account aggregator model will be suitable for consent manager is something the ministry has failed to verify. So now, in the case of opening an account with Angel One, that is one in a lifetime, I open an account with Angel One. Maybe I will open an account with Zerodha or somebody else, multiple such people. But with each of them, most probably I will have one account which will run for a long time. Consents there are once in a blue moon kind of a thing. Whereas in the DPDPA scenario, consents are obtained at the drop of the hat. For permission today, and I will install an app, and tomorrow I will delete this app, and day after tomorrow I will reinstall the app. So permission has to be re-established. So this kind of multiple requests for consent will arise in the DPDPA, and the account aggregator model is absolutely on this. And if the consent manager does not have visibility and he is only acting as a postman, and then I say that he is only a glorified log manager. Okay, think over it separately. I will not go much in detail. See, under these rules, the retention of the record is for 7 years. Okay. Now, some of the things which you must remember is why I say the rules is not matching the act. According to the act, consent manager is expected to manage the consent, review the consent, withdraw the consent. Now, how do you manage a consent if you do not know what information has been given? I know that, say, Vijay Shankar has wanted to have a Zomato account, and he had initiated this data principle, and Zomato asked for name and, say, physical address, and somewhere I have fetched and given that to them. But I don't know, as a consent manager, I don't know whether I have given the name as Vijay Shankar NA, or Navi, or Vijay Shankar Nagaraj Rao, because all that information goes from my secondary data fiduciary. I don't know whether you are able to understand this model of account aggregators. There is a principal data fiduciary who wants the information, and the consent manager intervenes, but the consent manager has to fetch the information from a secondary data fiduciary and then supply. And the consent manager doesn't know what the secondary fiduciary has supplied. So secondary fiduciary might have supplied my name as Vijay Shankar Nagaraj Rao. This consent manager doesn't know, because my account with the consent manager may be only Vijay Shankar NA or something like that. Then there may be an email address which may be different with the data secondary data fiduciary. There may be a physical address which may be a different thing. So what this secondary data fiduciary has supplied to the primary data fiduciary by way of data is not visible to the consent manager, but the consent manager is standing as a kind of a person who is authorizing that so-and-so asked the consent and so-and-so gave the consent, and there is a consent artifact which has got a number, etc., etc. Now, how do you manage this if you don't know what is the information given? How do you review it? How do you withdraw it? So the law expects that the consent manager shall have the visibility, shall take the responsibility, and therefore he can manage, therefore he can review, therefore he can withdraw the consent as if he is a power of attorney holder for the data principle. This was the original intention of Justice Sri Krishna when he introduced this concept of consent manager, as I interpret. Okay, we have to ask only Justice Sri Krishna whether this was his intention, but I feel this was one of the unique features of this consent manager, because if that was the case, we could have looked at specialized consent managers. As I have frequently said, a consent manager for minors, there could be a specialized person. There could be a consent manager for, say, some hilly region where some tribal population is there. They don't understand any language other than the tribal language. There may be a consent manager who is able to work with them in that language, and that person will provide the consent. So that kind of advantages were there if the consent manager was able to have the visibility. That has not been provided. Okay. So these are many of the reasons why I say that this is badly structured here. Okay. And as far as the obligations are concerned, there are some very important obligations. All of that are important if the consent manager is having visibility. For example, consent manager should have a 2 crore capital. And if a consent manager, obviously he should not have conflict of interest with the data fiduciary. So he cannot be a subsidiary, directors cannot have a relationship. Even the key management personnel of a data fiduciary and this consent manager cannot be common. So all these things are there. Okay. These are the obligations. At the time of registration, the consent manager has to produce an audit report. The audit report will be not only for the technical aspects of the platform, that it is an interoperable platform, any data fiduciary can use it with an API. There will have to be 2 or 3 APIs, one API with the consumer, another API with the data fiduciary, another API with the data supplier. 3 APIs will have to be there. So the auditor will have to see whether the APIs are working properly and other things. Plus, the auditor will also have to see whether the legal requirements as per the what we call as fit and proper criteria are fulfilled. So whether it's a 2 crore capital. Now, to understand that there is no conflict of interest, the rules say that if any of these KMPs or the directors have got more than 2% shareholding in the data fiduciary, that has to be disclosed. So there has to be a disclosure about the shareholdings of the KMPs and the directors in the organization itself, more than 2%, and also on various other companies. If I have got more than 2% shareholding in Reliance, okay, and I am the director of this consent manager, I don't know whether I am eligible for being registered, because at least I have to say that I cannot be a consent manager for Reliance, because that is a data fiduciary with whom my director has got more than 2% or some shareholding. These are some of the things which are there in this particular Schedule 1B. And this stringent fit and proper criteria is relevant if the consent manager is expected to have visibility to the data, and we are afraid that he may collect all this data and tomorrow run away. Therefore, I want him to have a 2 crore capital, and I want him to ensure that he is not and also this has to be a company in India, that is constituted in India, which is also correct, because I don't want a foreign company to become a consent manager, collect all the information, and like what TransUnion said, did in the case of CIBIL, transfer the equity to a foreign company so that all the access to the data is now available with the foreign companies. These things should not happen. Therefore, stringent restrictions are required. But if there is no visibility to the data, then why should at all there be any conditions attached to the formation of the consent manager? If I am a consent manager and if I have a platform which somebody is auditing and certifying that I cannot have visibility to the data, and that is accepted by the DPB before accrediting me, then it means that I am only a person who is maintaining a record saying that some data fiduciary raised a consent request. It came to me, I got the confirmation, and then instructed some other data fiduciary to transfer the data, and I have the record of this. If that is all the activity of a consent manager, why should I need to have a 2 crore capital? Why should I need to have this 2% share limits, etc., is a question. So I have raised this issue a number of times. Somehow I have not been able to convince the ministry that what they are doing may not be correct. I hope before the final rules are released, they will again take a relook on this. Okay. Fine. So whenever we get into this consent manager, it takes a lot more time than what is required. Anyway, fine. I was tempted to raise this because recently we have had interactions with many consent management software developers who are all very loosely calling their software as consent manager. And there are people who are buying such software and thinking that they are installing a DPDPA compliant consent management system. I don't want them to do that mistake, because if they come for audit with FDPPA, we will reject that compliance. Okay, then it will be creating a problem for the company as well as the consent manager. So I suggest the software developers also to be circumspect when they say they are DPDPA compliant consent management system. Okay, fine. Now we'll go to rule number 5. Rule number 5 talks about the processing for personal information by the government for subsidy benefits, etc., for which the government may indicate a particular information, which is called the standards of processing. Basically, the standards of processing, what they are indicating in this rule number 5, only talks about this lawful processing, purpose-specific processing, data minimization, which are all considered as privacy principles. So the same thing is applicable to the government under this rule number 5. Then,
Sir, sorry, sir. Are these not exempted? Rule number 5, transaction with governments for legitimate purposes. Are these not exempt?
the exemption under section 17 is for certain aspects like the consent and the rights, but for security and other things, it is not so. Even
Okay.
So it is partially exempted, partially not exempted. So the government has specified certain, you can say something like a due diligence. Okay. What it says is that these principles are essential if you want to claim the legitimate use clause, because this comes under either legitimate use or under exemption. Exemption is available only for law enforcement kind of reasons.
Correct.
Those come under the Article 19(2), come under exemptions. Okay. Rest of the people will have to come under legitimate use. So under legitimate use, still there has to be certain norms for processing. So they are suggesting that these normal principles of privacy, like data minimization, etc., are required. Okay. Similarly, when it is given for research purpose, it is legitimate use, you can give it, but still obfuscation, de-identification, these are all considered as recommended ways of transferring the data for research. Okay. So that is why they have given the requirements for subsidy, benefits, service, certificates, license. These are the things which come under this rule number 5. Okay.
Okay.
Yeah, rule number 6 is headlined reasonable security safeguards. So it is a matter of attention for all our information security people. What this rule says is it suggests that general information security practices such as encryption, obfuscation, masking, etc., should be used, and also virtual tokens. I think virtual tokens is one of the most important security measures which will be promoted after DPDPA comes into existence, because it addresses many of the compliance issues much more than any other form. So access control, log monitoring, then ensuring business continuity, detection of unauthorized access in something like the data leak prevention, and contractual binding of data processors, and any other technical organizational measures. All of them have been mentioned as reasonable security safeguards under Rule 6. Okay. So we have, of course, taken all this into consideration, and even your ISO 27001 will take these things into consideration. So there is a specific requirement of information security safeguards to be applied to personal data to which the particular act is applicable. Okay. Then rule regarding data breach notification, it says that on becoming aware of a personal data breach, the data fiduciary should intimate each affected data principal without delay. Okay. It doesn't specify a particular time. It simply says without delay. Certain says 6 hours. Here it simply says without delay. Okay. On becoming aware, of course, is when you are confirmed that there is a personal data breach. If you suspect that there is a non-personal data breach, then DPDPA is not applicable. Your certain 6 hours is still applicable. Okay. Then what you inform data principal without delay is description of the breach, consequences of the breach to the data principal, measures implemented to mitigate the risk on our behalf, and suggested protective measures which the data principal has to take. So this data breach notification template, if you are designing, please remember this is different from the template which you may be using today for certain or under any ISO or under GDPR, because you have to mention here the measures which the data principal has to take, like say your password has to be changed and so on. I gave you and the other day showed the notice which Angel One had sent recently for their data breach, and none of these things were there. Okay. And data fiduciary shall also intimate the board without delay, and then within 72 hours, a much more detailed report. So it's understood that this without delay, immediate instant report may not have all the details, but the organization has confirmed that there is a personal data breach. Then immediately one report has to be sent, but they can take time up to 72 hours for giving a more detailed report. If they need time even beyond 72 hours, they can always seek it from the Data Protection Board. Data Protection Board will provide that. As far as the data principal is concerned, immediate report is all that is mentioned, and that is basically to put him on the alert and ask him to take some immediate steps, because he is not going to give you back any directives of what you should do, whereas in the Data Protection Board may give you the directive. So there is a separate data breach notification to be sent to individuals and a separate data breach notification to be given to the board. Board may even introduce a form in their website where you may file a data breach notification. Okay. Any questions on this data breach notification?
Sir, I have, sir. So first question is definition of the breach. The reason why I'm asking is, let's say if, for example, in our company we have some instances where we have excess information shared. Like if I have asked for employee number, employee ID, I also get the employee address and so on, which is not relevant for me. That is one aspect. Second aspect, sometimes by mistake, my salary details, instead of sending it to Mahesh Prasad, I send it to Mahesh Kumar.
Yeah.
Okay. So that's actually an incident. Now, in this case, though it is internal, immediately we are able to identify. We ask the recipient to delete the email, confirm back to us, and then we report it as an incident. And we try to work with the people who have, impacted this incident. Now, will that be called as a breach? Or if someone misuses the information, like if I have shared my bank account number and they try to misuse with that information, that is called a breach.
Okay. Now we will go back to the personal data breach definition in DPDPA. Okay, that is the best source. Is that not?
Yeah.
Personal data breach means any unauthorized processing of personal data or accidental disclosure, accidental acquisition, accidental sharing, use, alteration, destruction. All these are considered as personal data breach. It relates to personal data, which is data which is identifiable, etc. Okay. So this accidental disclosure of an information beyond what was supposed to be disclosed to that particular person. There is, you wanted to give some explanation, but you gave a full, it is a breach. Okay.
Okay.
So the risk attached to that is limited because it is not an external leak. Okay.
Correct.
All your employees, including that recipient, is bound by certain NDA. So you can say that breach has happened. Okay, you cannot deny that breach has happened, but you can also qualify your data breach notification report saying that no damage has occurred because of the nature of the breach. And you have taken these additional measures, etc. Okay, so
Okay.
that is how perhaps you have to treat this. To treat as if incident has not happened is also not good enough, because we don't know this one person whose data has been leaked. Tomorrow he may raise an objection. Say it is ultimately his discretion to say that by revealing my salary details to somebody else, you have actually created some kind of a damage to me. Okay. So,
Okay.
so you have to handle that within your employee workforce. And as far as external DPP is concerned, you may try to say that we have taken, this is accidental, not intentional. It happened due to some technical failure, which you are supposed to correct subsequently, and then satisfy them, then they may not impose any penalty. But in terms of the grievance of your employee whose data was released, you have to handle that separately.
So, if my understanding is right, so internal data breach may not be reported to the DPB, but it has to be at.
I don't know whether you can take that judgment that you need not report it. Okay, as of now, they have not said that.
Okay. Okay.
What we have suggested in our recommendations is that, first of all, we should have a bifurcation of provisional data breach, where I don't know whether the data leak has happened or not. Okay. And then the real data breach. Okay. Secondly, whether all these incidents, which may be numerous in an organization, should be reported. And if it is to be reported, can it not be actually put in the form of a fortnightly report or a monthly report instead of without delay immediate report? So they can classify these breaches of low risk, no risk breach or something like that. And then say, okay, you send me a monthly statement of such reports instead of sending it as and when it occurs. These are all things which the Data Protection Board has to think, and this rule needs to be properly modified. Right now, there is no such. Okay.
Okay. Okay. Fine. And one last question. Sorry for that. What happens if I don't report within 72 hours? Generally, we are bound to pay penalties, or do we get a warning?
No, DPB has the discretion to impose penalty.
Okay.
Okay, it's not that you have to automatically write a check. Okay, they will take cognizance that you did not report. Okay, then if during their inquiry they find that you are negligent, first of all, in allowing a breach to happen. Okay, that is a fact which has happened. Secondly, you also made a second breach of compliance requirement by not reporting it in time. So for both, they may impose penalties as they feel is required. Okay.
Okay. Okay. Right. Right. Thank you, sir.
Okay. Yeah. Now, rule number 8 is an interesting rule which talks about time to deletion. That is, when a data principal has given you some information and afterwards he has forgotten that he has got an account with you, he never comes back, then what to do? In fact, when you try to get consents for your legacy data, you will come to a similar situation. There is a legacy data, you send the notice, you don't get any feedback. Okay. What this rule 8 says is, in certain cases, they have prescribed that after 3 years, you can delete the data. But before deleting the data, give another 48 hours notice to the person saying that since you have not been using our account for last 3 years, we will be deleting your data in the next 48 hours. This will apply only to certain cases. In the rule, what has been mentioned is a e-commerce entity having more than 2 crore registered customers, then a social media intermediary having more than 2 crore customers, and an online gaming intermediary having more than 50 lakh registered users. For these three kinds of entities, 3 years is indicated as the time after which the data fiduciary has to delete the information. This is more or less like a mandatory deletion which should happen. Apart from this, when the purpose is over, there is an obligation to delete. When there is a withdrawal of consent, there is an obligation to delete. If neither of that has happened and there is no other law which requires this data to be held, you can consider 3 years as the time limit after which you can initiate the deletion. Okay. Rule number 9 talks about provision of contact information of the DPO or the DPO on the website. Or the compliance officer. DPO is for the significant data fiduciaries, others compliance. Okay. Now, what I take from this is that the law has recognized that there is something called business contact information, and that needs to be publicly disclosed. So, which means that officials have got a business contact information different from the personal information. So, this is a principle which can be extended in other contexts also, not necessarily only for the DPO. Say, suppose what is CISO's email address? Okay, CISO at so and so. Okay, that is also a business contact address. So that interpretation seems to be validated because the government has recognized that there can be business contact details of an official. Okay. Then we come to rule number 10, which talks about the verifiable consent for the minor or the disabled data principle. Please read this rule very carefully. It says data fiduciary shall adopt appropriate measures, which means that it is the responsibility of the data fiduciary to find out what is the appropriate measure to get verifiable consent of the parent. Remember, the consent cannot be taken from the minor. Consent is to be taken from the parent, and it should happen before processing, and he should observe due diligence and check that the individual identifying himself or herself as the parent is an adult, which means that the age verification is required both for the parent. It is also required for the minor because there has to be a due date for this consent of the parent. So you cannot have only the age of the minor. You should also get a confirmation that the parent is an adult. Okay, parent, we did not have the date of birth, but I need a confirmation that the person is more than 18 years. Okay, as far as the minor is concerned, I need the exact date of birth. Okay, these two have to be collected as part of the verifiable consent. Okay, and it is the responsibility of the data fiduciary to find the means. Government is not required to tell you how it is to be done. You have to identify the date and this thing. But government is facilitating this by today allowing Aadhaar to be used for by private companies. In fact, this is a very important subsidiary service which can be given by some technology providers, including those AUAs and others, who can actually provide what I call as age certificates or age cards to people. Okay, I can have an age card which only says that I'm above 18 years of age. Then for my minor children, they may be given an age card with the date of birth and the name of the guardian. So such age cards need to be introduced. Then this verifiable consent will be feasible. Okay. So in the case of disabilities, see, it is a challenge is a little more because you have to identify the disability. Disability essentially means mentally he is not capable of taking decisions. It is not a question of age because even an adult may be mentally disabled. So your age card will not help here. There is only a doctor's certificate or a court certificate which will be helpful. So in all such cases, there will be a guardianship certificate issued by the court. So that is the only thing which can verify the disability. Verification of that and whether that can itself expire. Suppose a person is unwell now and after treatment, after 2 years, he regains his capability, then is it, suppose he goes back to the court and says that I no longer need a guardian, I will handle my affairs myself. Then how do you verify all these things is a challenge. This is also something which will take its time, and there has to be service providers who will be able to do this. There is a provision, availability of some services, but the only thing is those service providers need to be coaxed into coming into this particular line. I have been talking to one person in Bangalore, but he has not come back with the readiness to handle this kind of verification of disability. Okay. Then now, in the case of minors, there are certain restrictions in processing, like you should not use the data for targeted advertising, profiling, etc. So, but those things, there is some exemption. And rule number 11 indicates that certain establishments like clinical establishments, healthcare profession, organizations, schools, some of them are exempted from the processing of minors' data, including profiling, okay, because they need to actually monitor the minor, okay. So if you are one of those organizations, then you may be able to process the data, but this is something which your legal department and has to certify that you are eligible for these exemptions, okay. Then rule
Sir,
number.
I have one question.
Yeah.
Sorry. In our company, if we have a department, medical department, like the doctors, can they be exempted under this rule? Only for that specific department.
Yeah, that is processing of the data for that health-related service.
Correct.
It is subject to the context. A doctor attending a minor is exempt from processing his data.
Okay. Okay.
That is, he should have the ability or eligibility as a category of data fiduciary. Secondly, it should be applicable to the context. He cannot take his patient's data and give it to some other context, process it in some other context. Okay. Same way, when we talk of schools and other things, so schools for monitoring the students' behavior in the school, they are permitted, but they cannot take that data and sell it for some insurance company or something like that.
Yes, I understand. I get it.
Both eligibility as well as context is important. There is a table in the particular schedule, 4th schedule. You can later on look at that. That gives the class of data fiduciaries to whom this is applicable and the conditions under which this exemption is applicable. Okay?
All right, sure.
Yeah, Das Gupta?
Sir, I have a small question regarding when the minor attains majority. So then in that case, the consent needs to be revoked from the guardian and the fresh consent needs to be taken from the minor who has now become a major.
Yes.
Yes.
So you have to diarize that. And see, you cannot take it one day before also.
Okay, sir.
Okay.
One question.
You have to let the person become the major and then take the consent and simultaneously revoke. There may be in between a gap of a few hours or whatever is that has to be handled separately. Yeah. Some other.
That previous slide, rule number an exemption from processing minor data, right?
Hmm.
There, if you could just go back to that slide, are there no specific activities to which it has been exempted for restriction, right?
It is there in the fourth schedule. If you can simultaneously open the DPDPA rule and say fourth schedule, for example, it says just one column, one row I will read out. A data fiduciary who is a clinical establishment or a mental health establishment or a healthcare professional. Conditions: processing is restricted to provision of health services to the child by such establishment to the extent necessary for the protection of the health. Then one more purpose, okay? A data fiduciary who is engaged by an educational institution, creche or child care center for transport of children enrolled.
That's okay. My thing was the education institution itself. Now, education institution itself will track and monitor the data of minors, for example, for academic performance and everything, right? But they should be stopped from selling that data to some other sharing that. Where is that? Where is
that is the condition attached to the extent necessary for the protection of health, to the extent necessary for that education or something like that.
They'll say, okay, it was necessary. Let's say there are some software provider who will do some kind of test and all these things. They'll say, okay, this software will help assist in the student performing better and all those things, and also those loopholes will be there, right?
I understand. I have myself undergone such tests earlier as a high school student and other things. Now that software provider, let us say, who is he? Is he a data fiduciary?
Yes.
Yes. So you
not an education institution.
You have a contract in which say you are a data fiduciary. We are allowing you under the contract to take the data of my students.
No. Sorry. I'm stopping you there. Even that sharing should not be allowed, if I would say.
Because you are justifying the purpose. No, say you are saying for the benefit of the child, for example. I am doing periodical health checkups. Many schools do it. In fact, many of the early diseases are sometimes spotted there. It's okay, which is happening. Okay, whether it's mental these things or color blindness or something else. Many times it is useful. I don't say it is not useful. Okay. Now they are actually inviting an external person to do that. To that extent, they're providing the data. They can have a contract in which that external advisor does not take the data. He only provides the service and goes away. It is possible in some cases. In certain cases, it may not be possible, in which case that person becomes a joint data fiduciary. And your contract, if it specifies that you are a joint data fiduciary under DPDPA, then he knows what are his responsibilities. He also can process it only for the purpose for preparing a report, handing it over to the school. Then afterwards, he may or may not need to retain that data, or he may retain the data in some form of secured manner. These are all the responsibilities which he has to take care.
But many times hospitals share this data with insurance companies, share data with third parties. You know that. If Narayana Health, for example, is now starting an insurance subsidiary.
I understand. If that has to be done, there has to be a group insurance scheme. The school should say that we have a group insurance scheme for all our children at a consensual this thing, and take the consent for sharing with that insurance company. Otherwise, arbitrarily they cannot share. Okay. Right? We'll take a few more minutes and this itself. Now, significant data fiduciary. Rule number 12 is about significant data fiduciary. The government says that they will appoint a committee, and that committee will provide the guidelines on what class of data fiduciaries need to be declared as significant data fiduciary. Okay, we have discussed that again earlier. Now, rule number 13 talks about rights protection. There are 4 kinds of rights, and you need to have suitable. See, these are all things which the government does not want to give you a detailed checklist. In fact, I don't recommend government to give a detailed checklist. So many companies are saying that there should be more clarity. Clarity does not mean that the government will give you the details. Like today, some people expect Supreme Court to give the details of how the government should legislate, no? And Supreme Court thinks that it is okay in certain cases. In certain cases, it will say, let the government come up with the rule, then I will comment. Likewise, here government says that you are a data fiduciary, you exercise your due diligence, you develop appropriate facilities. If something goes wrong, then I will come and interpret whether what you did was due diligence or not. So that is the stand with the government takes. That is the reason why DPOs and companies need to have a thorough knowledge of the law. You cannot expect the government to give a checklist and you can have a software which just puts check marks and your compliance is done. That is not going to happen in India, and it should not happen also that way. The organization needs to have a thorough understanding of the law. And even if you use automation software, every output of an automated software will have to be certified by the compliance officer that yes, this is the right thing to do. So that applies to this access request, correction, erasure, nomination, and grievance redressal. Okay. Then this rule number 14 is related to the cross-border transfer, and data fiduciary shall meet such requirements as the government may specify. So government is holding its cards straight to its chest. It may come up with separate rules on this. About this also, I have written a detailed article day before yesterday or so in navi.org. Please go through that. Okay, so right now, no blacklisted countries are there, no whitelisted countries are there, but government may come up with such lists as we go forward. Now, as far as exemption for research, etc. is concerned, a schedule mentions what are all the requirements. Basically, the privacy principle. This is again applicable only for the government and related things. Okay. Now, rule number 16 and 17 relate to setting up of the search cum selection committee for the chairperson and the members of the data board. And if you have time, you refer to the comments which FDPPA has submitted to ministry on this DPDPA Rules 2025. We have made some specific suggestions on this. You can access that in the website of FDPPI. There is a link for library. In the library, comments on DPDPA rules will be available. So some suggestions are there. Otherwise, this is something which is administrative in nature. Then 18 is also about the administration of the DPB. Let us leave that. Functioning of the board as a digital office is almost a mandate. The board shall function as a digital office, this rule says. So they need to actually receive complaints online, resolve also online. They can only use physical mode of interaction as a very exceptional case. Okay. Then terms of appointment of officers is provided in the schedule. Then the last two rules I will just mention. Rule number 21 is about the appeal. The appellate tribunal designated is TDSAT. So after the DPB resolves an issue which is not satisfactory either to the data fiduciary or to the data principal, the appeal will go to the TDSAT. Now, whether TDSAT will appoint, use the online method or not, we have to wait and see. They are not fully prepared for online interaction, but they also may have to get themselves ready, because this rule says that this digital shall be filed in digital form. Okay, appeal will be filed in digital form. But to the best of my knowledge, TDSAT is still not ready to accept petitions entirely on digital form. Okay. Some of you who have attended TDSAT hearings should be aware of it. I have attended TDSAT hearings 2 years back, but now things might have changed. The last rule is a very important rule. It says there will be a power to call for information by the Data Protection Board from the data fiduciaries. Okay, different authorized persons have been designated. If information is required from the state, there will be an officer for that. If the information is received to be received from other organizations, there may be a separate officer. And including, it is here that it says that for carrying out an assessment for notifying any data fiduciary as a significant data fiduciary, there may be a designated officer. So this is rule number 22. This is something which was not there in the earlier version. It has been introduced. So this is the set of DPDPA rules which are currently under further discussion, in the sense that public comments have been given and government is saying that within 1 week, 2 weeks, this will be released. So we are waiting for that.
If they don't have the contact details, legacy data might have collected long time ago also. So if the email ID or contact number they are not available, or even if they are available, they are not working, because the data principal may have changed those details. So what is the option available for the data fiduciary?
One minute. I think I'm on. Am I on mute? Are you able to hear me?
Yes, sir. You are audible.
We can hear you, sir.
Yeah, we can hear you.
Okay. So in case there is no consent from any of the existing data principles, it means that we don't have the legal basis to process. Of course, if you want to retain that for any specific genuine reason, you can document that and put it in the archive. There is a possibility in certain cases that you can try to give a public notice or something like that, but I don't think the law currently supports a situation where you can take the non-response as a deemed consent. Okay, so it's unfortunate that if you do not have contact information, if you have contact information or whatever old contact information you have got, please send the notice there so that you can document that you made your efforts to reach out to them. And to those people to whom you do not have the contact details, release a public notice and put up a notice on your website saying that for those who are not contactable now, we are archiving your data, stopping the processing. Okay, and we will wait for, say, 3 years or whatever is the reasonable time, after which we may delete. This kind of a notice can be either given publicly or on the website, but you have to remove that data from processing in the normal course. Okay.
Okay, sir. Okay, sir.
Okay.
Even in the public notice, I think they should not disclose the names. They have to give a general notice.
Yeah, no, you just give your contact number so that
Yes.
persons may contact you, the
Yes.
organization, to get further information on how to renew their consent so that they can continue to get your services.
So they have to tell that we have already communicated email on the email ID available in our database.
You can
And
mention that if
Yes.
you are not able to contact some of the people through their emails already provided,
Yes, sir.
therefore we are asking them to contact us once again.
Thank you. Thank you, sir. Thank you, sir.
So Navi sir,
Yeah.
just to share my screen to start with, we will discuss one,
Yeah.
and then again further we can continue.
Okay.
Yeah.
Ramesh sir, just one question. Navi sir, maybe you want to discuss it now or after later. See, Navi sir, you've been saying that this digital signature is required to establish the legality of a consent provided on a website, right? Is it only in case challenged, or is it the default position?
No, actually, if you go to the earlier rules, that is the DPDPA rules which we discussed in July, There,
Okay.
the rules was very specific to say the digital signature is required of both the data principal as well as the data fiduciary, because the consent was a contract. Okay. They had given a model notice there, and it was present in that model notice. That model notice has been removed in the latest rules. But the law requires that the consent has to be like a contract, and the onus to prove that the consent has been taken is on the data fiduciary. Therefore, it is in his interest to ensure that the consent is properly authenticated. Now, authentication requires digital
Sorry,
signature.
I'll stop you there. See, I'm just focusing on the first part of it in the sense that, um, uh, as you said, if that rule was earlier there and that rule is no longer there, should it not be interpreted as the intent of the lawmakers
Okay,
that
okay, I will tell you. Rule is still there. Model notice is not there.
rule number, which rule number, sir?
Now, that is in the consent itself. If you
Okay.
go to the earlier
Okay.
this thing, there was a schedule. I think it was right in the rule number 1 schedule. There was a model notice. Okay. Which specified how your notice should be taken. That model notice has been removed. Now, schedule has been removed. Okay. Again, we go back to the thought that you are the data fiduciary. Government says you decide. Now, that's why I said you can either take the digital signature, or you take the e-sign, or you take the section 63 certified record of the consent. So you, if there are anything else by way of which you can prove that this section 63 certified means it is like a witnessed document. Okay.
Look, I'll tell you the practical difficulty in that, right? With the digital signature token like the e-mudra and all of these fellows give, no? Now, as of now, only somebody who's an authorized signatory of a company and all of these, they take these digital signature tokens. Other people, by and large, don't.
Correct.
Right? And the number of times the consent is taken, number of situations, even mobile applications, something. Today, that token you have to insert as a USB into your laptop, right? You cannot insert into a mobile phone, right? So, if you really put,
I understand that situation. Now, in certain cases, like opening a new membership account, you can go for e-sign kind of a thing as a one-time requirement. But it may not be good enough for repeated things. That is where the role of a consent manager becomes important. Say a consent manager can have the consent of one client once for several consents to several data fiduciaries and handle this KYC. Okay. Now, the other one which I suggested, which is this witnessed kind of a consent, okay, which is recording the metadata surrounding the particular consent and keeping it on record, is an alternative. It is not.
How about solutions like DocuSign or things like that? See, for example, I took a Tata Teleservices, I took a web licenses from Microsoft. They provide an agreement, and in that you scribble your name or something. They give you that. Is that also not a digital signature in that case, or?
DocuSign basic service is not digital signature, because DocuSign is not a certifying authority. Now, if the writing on the DocuSign paper triggers a private key and public key issued under a certificate issued by CCA, that is, if e-mudra, I think they have introduced that service now, that DocuSign doesn't have operate on its own completely. Then that signing on the paper is a trigger to invoke the private key. And if the private key, public key is part of a certificate, then it is okay. But cost is still there. See, there is a cost attached to that. In fact, maybe more. DocuSign plus some certifying authority which is backing the DocuSign. In fact,
I'll tell you what, sir. Sir, when the Information Technology Act in 2000 was passed, many people, we are not into the field of privacy or digital data security at that point. We are in finance. So the way most people told us is, with the introduction of the Information Technology Act, even an email acceptance is good enough to establish a contract.
No,
That is the way we were told.
Let us discuss that. Email is can be an offer, it can be
Okay.
an acceptance, but it is
Okay.
like an undigitally signed agreement.
Mhm.
Now, contract can be oral, contract can be without signature. Okay, that is the oral
Okay.
deemed contract.
Okay.
Therefore, when you exchange emails, there is a
Mm.
basic document which you are
Mhm.
saying that this is what was proposed, this is what was accepted, but
Mhm.
that will not be equivalent to a signed contract. Now, what is the difference between a signed contract and a deemed or oral contract? In the case of a oral contract, you can bring a third party witness. Okay, that is what I am
Okay.
suggesting in the section 63 kind of a thing. Okay. The
Okay.
event itself happens between A and B. Both of them have
Mm.
not signed, but C says that in my presence, A and B did it. Okay. So you are
Mhm.
bringing a third party without any vested interest to actually confirm, so that in a court of law that can be considered as one additional factor. That is why collect metadata and then certify it. In fact,
Okay.
I have a service of that nature in CEAC Dropbox. Nobody seems to be understanding the usefulness of that. But what I am suggesting is that collect that metadata, everything, dump it into CEAC Dropbox. As a CEAC Dropbox owner, I will record that event and then confirm that such and such an event happened. Okay, so that kind of a service will provide you without digital signature something else. But that also may have a cost. You can say that there is a cost. So e-sign, what is e-sign? In e-sign, any person who is having the Aadhaar card can apply digital signature valid in ITA 2000. Am I correct? He has to only fill up the Aadhaar number or the virtual Aadhaar number. Then the API, if it is configured, will send an OTP to this person. And once he gives an OTP, a digital signature gets attached to the document. Is it not? Now, this is the least cost option as of now for obtaining a legally valid electronic signature. But that
Effectively, sir,
cost,
what he's saying is, if all of these mobile apps that I download and they say, please accept consent to this, consent to this and all, I can effectively disown all of them saying that I never gave my consent as long as I know that the digital signature is not being collected, right?
that comes under now either the dotted line contract or a deemed contract, because
Okay.
the other party will say that after this you went ahead and started using the service, so it is deemed to have been accepted. Okay, but the details of the contract, that is the clauses, you may still dispute. That is, you may say, yes, I agreed, but I did not know that in clause number 27 now they are claiming something which was not known to me. So it can be voided in specific parts if it is not a digitally signed contract. So now I think if you are an organization, you should use a combination of this digitally signed consent, which you can take at the time of first establishing the customer contact, like opening an account, etc. For subsequent things, you can go back to this maintenance of the metadata and other things at your end, if it's possible, or if you want to further validate it, use the services like this AC Dropbox, so that there's a third party validation also. So that may be cheaper. So you may use a combination of the e-sign along with this metadata certification. I think that is more practical. And beyond this, what you don't do is the risk absorption. Government is not saying that if you don't do that, then this contract, consent will be invalid. Only thing is, if the dispute comes, you may not be able to hold on to certain clauses which you might have put on the form. So that is the risk absorption. So you may say that in my business, there is not much of a risk. I will accept that risk also.
Is it unique to India?
See, yes, it is unique because in India, digital signature or equivalent has become mandatory for authentication. Okay. In USA, it is not. And also in India, digital signature is to be supported by the CCA supported or accredited agencies. Whereas in USA, it is not so. A VeriSign can be a valid digital signing, and P2P may be used. Whereas in India, you have to get it from the certified this thing. So yes, it is unique to
Oh,
India.
very
Okay.
complicated and deep actually. It's,
No, complication comes because Information Technology Act introduced it so that it could support e-commerce contracts where financial risks and other things were there. Now, this act is saying that consent should be like a contract. Yeah, okay. That is where you are elevating the consent to a level of financial contracts, and therefore the authentication mechanism looks little.
okay, maybe we can take it offline further. This is a big topic
Yeah.
actually. Yeah. Okay, thank you. Thank you.
Yeah. Ramesh, if you are ready, you can start sharing the screen.
Yes. So what we will do, sir, we will go through one now because of the time. After that, we can discuss your
Yeah.
DGPI principle and then we can revisit back. Yeah.
Yeah. Yeah.
Are you able to see my screen now, Navi, sir?
Yeah.
Okay. So team, really sorry, I was talking on mute. So just we will try to go through this case study, right? Time to read that and then tell me once when you are ready. I'll just read on your behalf. Be with me. It says there is a company, Intelligent Auto Components, is a developer of an automobile software which monitors the car's activity, such as engine, brakes, steering, etc., and generates insights into the performance of the car, right, automobile, and the efficiency of the driving. That means the driver is also involved. Wherever I have put a little bit bold and different color, just keep that in your mind. The product has been embedded into the intelligent cars of your company. The feedback is being reviewed as an R&D output, research and development for further, for enhancement, etc. Now, this company, Intelligent Auto Components Company, is offering that they have developed an interface which enables the integration of the IAC software, the car's driving software, which controls now the essential items, brakes, steering, and engine operations to enhance the safety of the driving and the driver. One of the features is that when the car senses an obstacle, let's say in front of it, it reduces its speed to create the safe distance. As we know, in many of the new cars, it's already there. Automatically, it comes to an abrupt end, right? And when the obstacle is within the hitting distance, automatically it applies the brake or steer the car away from the obstacle so that the collision is going to get avoided. Now, keeping these three scenarios in your mind, as a data protection officer, as a security expert, management requires your views, comment on the situation from the DPDPA perspective. Now, what we can think of with this three paragraph as a problem statement, and what we are talking about last 5-6 sessions, Navi sirs, what are we, where that DPDPA, what perspective we need to look into. So just collate your ideas, and we are going to discuss another 2 to 3 like this, so that we are aware of, right, what, from where, which angle we should start looking into, etc. So can you please take your time, maybe another 2-3 minutes, and then tell me your views. Absolutely feel free, unmute it. Let's have a discussion that we need to look into this perspective, privacy and so on. Is that okay?
Well, so instantly, what I can look into is what is the applicability.
Very good.
I mean, is it applicable to Indian citizens?
Now look at it now.
No,
Whatever-
I mean, just
you're right.
first, as a first step, I will look into the applicability is what I'm saying. I mean,
Very
as
good.
it came, I just
Very
said.
good. Very good.
I'm still collating, just letting you. Thanks.
Super. Very good. Very good. We have to, that is a starting point. Absolutely. Very nice. Am I a data controller? Sorry, data fiduciary? Am I a significant data fiduciary, right? Am I a data processor, even though that law is very silent on data processor. And obviously, this is going to be decided based on the data, what I'm going to cover, etc. Correct? Beautiful. Any other input?
Yes, sir. Again, the applicability will depend on is it only the vehicle behavior getting captured, or along with it, the user, the car, the owner who is going to use it, his data is also going to be combined with it. Then it becomes applicable. If it is only using car data and not the registration details or any other details of the owner, then DPDPA applicability may not come into picture.
So the gender is the one thing that they can look into. So whether it is a male or a female who owns the car. And then the age is again probably can be looked into. I mean, just adding to what Mr. Sagar was saying. I mean, as a data points, if these are collated, then it is all the more I wouldn't say complex, but it is more to be looked into.
Excellent. Very, very nice.
So
I will
bullet
also
point
check in
says it
terms
will.
of whether it collects the location details or any
Geolocation.
biometric details for authentication to that software.
Yeah. So now, Radha sir, you were saying something.
Yeah, I understand. It collects the personal data of only two entities. One is of the owner, second is of the driver. The first bullet point says it also collects the data relating to efficiency of driving. That means it collects the data of the driver also.
Yeah.
So personal data relates to only two people, owner and the driver. Other than that, I think it doesn't collect any other personal data.
Okay.
So that's what
to add to what Sir has said, this Dasgupta here, sir. See, in insurance, it's quite, you are given incentives for safe driving. So when you are collecting all the driver details, basically habits, how he drives and everything, that data can be also used to incentivize on his premiums in terms of how the driver is driving the car and his nature of driving.
Yeah, very nice. Insurance comes into picture. Subrayadu sir, you raised your
Yeah, I think the most important feature would be once you're integrating it with the car driving software that control brakes and all, immediately the potential for harm comes into the picture immediately. The harm that it may cause to the driver understanding the role of the software and relying on the software, and if the software does not apply brakes or somebody on the road, some pedestrian gets killed or something, there is the question of harm immediately comes into the picture the moment you're talking about this interface that is integrating with that car driving software to control the brake, steering, and engine operation and all. So immediately, considering the harm, I think immediate DPIA has got to be done before.
Super. Excellent.
That is the first thing because the harm picture is immediately coming in the picture. Yeah.
Very nice, sir. Very nice. Thank you very much, all of you. This is exactly now as a DPO, right? Data protection officer. That's the course is really, right? We need to have these kind of multiple dimensions. Obviously, the risk assessment, or as Subha sir just now said, the data protection impact assessment from every angle is needed, starting from applicability to what kind of data we are collecting, where it's going to get processed, right? So that our roles are going to become more and more clear, because if the significant data fiduciary data protection officer comes in. Okay, I will just share my thoughts, right? Many of you, whatever you have shared could be there in that upcoming slides. Let's see. Now, we are saying that there is a software which is going to be developed, which is going to be integrated. That means, as look at it, the first bullet, what Subrayadu sir's bullet comes in. Any data protection impact assessment has been done, keeping the local, the laws, standard, and regulations as applicable. Where that car is going to be launched, which region, which location, which country, because each and every comes in. I understand my question is related to DPDPA, but as a data protection officer, we need to have that whole idea. And when you are talking about monitoring the behavior, right, of a style of steering That means we are talking about the driver, as Radha sir said. Obviously, right? The way Subrayadu sir drives and way Navi sir drives and way you drive could be totally different. That means I'm getting into that style of steering, the holding, frequency of applying the brakes, right? Applying the speed, increasing the speed or managing it, speed of the car, probably even location. Somebody already talked about, right? Even though it's not mentioned as a point over in the, these are all hidden probably. So as a DPO, we need to be very clear, the first bullet. Second, are we really looking into, right? If you're a software developer organization, that's what I'm talking about. When you are developing a software for an automobile, that intelligent automobile company, what we are talking about. Are we implementing security by design? Now, rule 4, what we talked about already, right? The expectation of the DPDPA or even other local laws and standards and regulations, as I talked about. GDPR talks about security by design, privacy by design. And we, from the DGPSI principle, we talk about compliance by design. Are we really implementing all these things? Keeping the data principle or a data subject as our prime focus, right? The third, because we have so much data, are we really trying to do something, anything called automatic profiling? Because if Subba sir sits in the on the wheel, right, as a, driving, I need to really set up his, that means I'm going to collect his behavior. Is it allowed? We need to be very clear. Where is the collected data getting generated? Where it's getting generated, where it is going to get stored? Is it going to be in the on-premises, in the car itself, or it is going to be in the cloud, on-premises, on your server also as an organization? Because all these things you are monitoring again, correct? That means I need to have this data. So whether immediately we need to think about, like, localization requirement comes into picture. Obviously, I cannot have the European Union guy driving my software, using my software in European Union, storing their data in Bangalore. I need to really look at the data localization. Then I need to have that instance over there. And probably I need to have their consent that I'm going to use this data for improving the performance or the efficiency over a period of time. So we need to think about it. Whatever the state data we are generating, storing, etc., is it getting encrypted? Because these data are very sensitive, specific to particular individual data principle or data subject, and hence the encrypted data, whatever I'm going to data at rest, is it being handled with the proper role-based access control or privileged identity access management is in place? Whether the data of the user A, Navi sir, as his data, can it be looked at by, let us say, Subba sir, right? As a best practice, he wants to do. Is it allowed? Because see, some of the, I know, like for example, in the surgery, the other doctors wanted to learn, right? Like a typical. So is it allowed if you have the consent and etc.? So the surgery itself is video which are available in the sites for other doctors to go through it to improve their, as a best practice. If it is allowed, yes, we need to have a look at it. Again, the first one comes into picture, the laws, standards and regulations, is it allowing you? Whether do you have a kind of proper management system is in place in case if there is a kind of incident, breach, security breach or a privacy breach? Do you have the related policies, process, structure is in place, roles and responsibility defined, and with whom what data would be shared in case of any, right? Investigation perspective, I need to share that data with regulatory authority, or if we are using an AI algorithm, last week also we discussed about a proper regulatory authority, it needs to be shared and showed to them, etc. This is if you are a software developer organization. Let me go to that next slide. As a car manufacturer, what you and me need to look at it from as a DPO, right? Whether the car manufacturer, because in his car, that software is going to sit, and he is also becoming a kind of probably a joint data fiduciary, right? We need to be aware whether he is aware, whether that whatever that software which is going to get integrated, right, which is sitting in his car, is he aware what data? And obviously, data protection agreements or contracts need to be in place between the car manufacturer and the software developer where it is going to go. At an enterprise level, I'm talking about. Whether the car manufacturer is providing the privacy notice, especially in the local languages, I'm here looking at DPDPA definitely. We talked about it as part of our schedule. It needs to be available in English or the local languages 22 are specified in our article. Whether the user has got an option no to say no for, no, I don't want you to track my behavior. That's what that question, automatic profiling, is it allowed? If it is allowed, which is enabled in the software, as a data principle, do you have an option to say no, right? As long as it doesn't impact the service, obviously one should have. I think last week, I remember the discussions, right? Consent when we talked about it. Now, we need to be very clear whether the law of the land allows you to monitoring the user's behavior. The first bullet of, right, what we talked about from the software perspective, from the manufacturer perspective, we need to think about it here. Automatic profiling, it generates insight into the performance of the automobile and the efficiency of the driving, which your car manufacturer need to be aware, and the proper consent need to be there, because he's going to be a joint data fiduciary in some of the cases. Any benchmarking done using this data and hence comparing my actuals against the benchmarking. Very good point. That means, again, we are taking that aggregation here, my performance related to what is available as a best practice, right? Then is it going to recommend something? No, you handle this way, or you don't apply frequent brakes and so on. Is this allowed? If an abrupt stop due to, what about the safety of others on the road? Again, I think Subhas sir talked about it. We need to be. Now, these are all obviously data protection impact assessment would have caught these kind of issues. We need to be ensuring that these are getting caught as a DPO. Whether the manufacturer is also getting a copy of the data of each user, because he might also be interested, right? Using this existing database, he might also wanted to further enhance and approach others, right, through them. If yes, other questions related to the data should arise, etc. This is for the car manufacturer. Moving on, users of the car, that is you and me, what we need to be aware of as a DPO, what you need to ensure, the data subjects or data principles, right? Whether the user is aware of what are all the data getting collected from me, and whether they are getting the consent from me, the car manufacturer, we need to be aware. That means the earlier one we talked about, privacy notice is given, and subsequent to that, consent is taken from me, from the user perspective. Are you made aware through the privacy notice that software is monitoring your behavior? And then I need to say yes, no, right? For automatic profiling, I need to have this provision in the software so to say no or yes. Are you made aware of automatic profiling? Are you aware whether your data is getting stored by the software provider, and also where all it is getting shared, right, with the car manufacturer, with the regulatory? For what purpose am I made aware through the privacy notice? Any benchmarking done using this data, my data, right, as we discussed, are you aware? And if it is an abrupt stop due to sensing an obstacle, what about the safety of others in the road, especially whoever is coming behind me, right? Because I am putting a brake, somebody is going to come and collide me. How am I going to be responsible? So from the users of the car perspective, we need to be aware. And I really I think Sagar or somebody talked about it. Insurers, they are coming into picture, insurance coming into picture. What kind of data they are going to collect? My data, right? The user's data. So as a DPO, you need to be aware. So we need to really look into those kind of questions. And in a nutshell, I would say that we need to look into every situation, every use case from different angles, right? If you are only applicable in your organization, only DPDPA, fair enough, no problem. As all of us agreed, you take with that applicability, what data is getting collected, starting from users, etc. Map against the requirements, and then we are safe, no problem. DGPSI principle, we are going to start, Navi sir will be talking about starting with processes, the focus, right? Inventory of the processes, which really gives you the purpose as well as the data getting collected for each processes, and map those, then we are safe. Otherwise, multiple laws coming into picture along with the DPDPA, please be aware of from every angle. Yeah, so that is, I would summarize. Now, I wanted to go through this another case study. Think about it, and tomorrow on this after DGPA principle covered by Mr. Navi, we will again revisit this case study, how it is fitting in with the DGPI principle. I would be very happy. So another 2-3 minutes, please take a note of this case study quickly. I'm not going to discuss now today. We will discuss it tomorrow. So Navi sir will talk about DGPA principle now. So you know one before DGPA principle case study what we discussed, the second case study. Now we are going to discuss DGPA principle and we'll revisit this tomorrow. Are you comfortable, all of you? Make sense? Some kind of idea on as a DPO from every direction what we need to really look at it.
Ramesh,
Okay,
sir,
sir.
Yes.
one question.
Yes.
In one of the slides, you told that if it is there is an abrupt stop, and what about the safety of others on the road?
Yeah.
How is it relevant to our DPDPA
Ah,
provisions?
very good question. This is what Subrayat sir also talked about it, right?
Yes.
Now, who is responsible? Something happens now because I'm just using the car. I'm just using the software provided. I'm using the facilities provided in the car, right? So we need to be aware of at least whether they have taken care of all these things at the time of designing the system, correct? Am I made aware that, don't worry, there is a kind of protocol, etc. we have in place to take care if there is a kind, if it is not your mistake. So question is from that perspective, that awareness and whether the risk has been already identified when they are designing the system, security by design or privacy by design.
Okay. Yes,
Subrayat sir, am I right? My interpretation on your question that because I may not be.
Yeah, correct. See,
Yeah,
it's about
yes.
risk assessment, right?
Absolutely.
Risk assessment is the starting point of all
Correct.
data
Of course.
protection, right?
True,
Correct.
sir, true. Thank you, sir.
Very good. Thank you very much, Radha sir.
Ramesh sir, one minute I will take. Sir, I was just thinking, in all this process, there is a high risk of data breach because collection of data is happening.
Yeah.
So you feel that accountability should be clearly defined in case of a data breach.
Excellent. That's why we looked into this, the 3 paragraphs from different scenarios. Now, let's say that I'm only a software development organization, right? So I'm going to develop the software and going to give it to the car manufacturer. Now you are a DPO of this organization. I'm the DPO, right? Am I looking into it, all these things? Because my software is going to get integrated. We already have that use cases, right? I'm working for an, as I told you, healthcare organization where my software, which is getting developed in Bangalore, is getting used across the globe, sitting in every hospital, every region. So when I am developing the software at Bangalore, the applicable law, standards, and regulations, we are looking at very sincerely. As I said, whether it is in GDPR, EU, whether it in US HIPAA, if that IEC 81000-5-1 standard, I'll tell you, it's mind-boggling. If I had to give you that entire list in Excel, it's almost around 60 to 70 we look at, and then we tick it whether it is applicable, not applicable to that region, where, etc. So I think I'm answering you. I am a DPO from the software developer organization. At least I will look into all these things. Simple. Am I implementing security by design? Am I performing the cybersecurity assessment? Because it's a software. It's going to sit in it's an IoT now, correct? It's sitting in the car. It's a dynamic. It's a tracking. Is it allowed? So all these things, I will look at it. Now, let's say that from the car manufacturer, let's say you are the DPO, what you need to look at it. So I think all of you answered applicability. So first thing obviously should come into what is my role with this particular software or that particular activity, as long as we are clear. And obviously the starting point after your applicability, DPIA, once when I am clear, data protection impact assessment, perform, many of the things will fall in place. Needs to be supported by the TOMS measures we are talking about.
Ramesh, sorry to interrupt. So one point which I think is not covered is from the data transfer point of view.
Yeah.
How they are transferring the data.
Yeah, very good.
Whether it is
That's what I
within the
said. This is
country
just
or outside the country as well.
beautiful, sir. Look at it. I'll tell you some of the things we already said that where the data is going to get shared. Okay. Whether the car manufacturer is also getting a copy of the data, and if any question related to the data should arise, Other questions related to the data management should arise, obviously, whether it's a cross-border, whether it's within the country, and then localization as we talked about. I will tell you one more place we have captured this, if I can tell you. Whether you are made aware that all the data is getting collected from you is right from the user's perspective. From the software also, we are talking about where it is going to get shared with the whom. Okay. Even with amongst the users, are we going to share the data? Correct? So we need to develop it further, obviously.
Ramesh sir, one more point. It's Indrajit. It's one more point. Like
Yeah.
in India, we have multiple drivers of an automobile.
Oh, beautiful.
So means India, so it can be this data of driving pattern can be linked to the owner of the car.
That's
But
exactly.
we
Yeah.
so in India, where we have multiple person in a family who drives the car, so multiple profiling option or something we need to means that is
Yeah.
something which I was thinking.
Excellent bullet. Excellent bullet. That is why what Radha sir said, that his bullet is that we are going to collect the data about who is sitting on the wheel. Now, morning you may be sitting, afternoon your son may be driving, evening your wife may be driving. So obviously, if at all the profiling is, that profiling also need to be taken care. Who is sitting on the wheel? It's like there was a big discussion. IP address as one of the important attribute to identify PII. Is it really making sense? Still there are, as far as I know, my interpretation, still there are discussions, because if you look into the cafes, right, where people go and used to use, you had used it between 10 to 11, now 11 to 12, I am using the same system. If that IP address is a static IP address, now what will happen? So it has to capture relevant data. Who is sitting on that machine, on that wheel, on that particular time, if at all, if it is going to be enabled, and if you are going to say, give the consent to collect the data. Very valid point. So all these things we need to think about it as a DPO when we are looking at any data protection impact assessment. Thanks, Indrajit sir. Absolutely. So finally, yeah, thank you very much. Just have a look at it. Hope please make a few of the bullets about it. You can think about it. We will discuss it this after Mr. Navi's DGPSI principle, because now you know the DPDPA starting from applicability to the rules what Mr. Navi talked about. Now the important is the DGPSI principle, which is the only framework at this point of time which exists in India, as far as we know, which can be used to implement DPDPA 2023. So let's hear from Navi sir. Again, we will come back here. How DPDPA further for every bullet we'll discuss tomorrow. Is it okay?
Yes, sir. Okay.
Yeah. Navi sir, I will unshare. One help I want, Navi sir, please make a note. One, you remember that in Mumbai, in one of the program where Adupu sirs last year, we had consolidated around 7 case studies. That slide you send it to me later if you don't mind.
Yeah, I will send it, and even
Thank you.
this thing, if we have to carry it over tomorrow, I will share it with them so that they can study it.
I will give that last slide to them without confusing. Okay, so that let them go through it. Then we will give that consolidated one tomorrow, sir, please.
Okay.
Thank you very much. You can take it over now from here. I will share that last slide with them. Thank you. Bye.
Yeah, friends, as you saw, the complications involved in a case like what we discussed, because particularly because the data is that of the driver, but behind that there is a static owner. So if it's insurance benefits for good driving, the benefit goes to the driver, to the owner. At the same time, if there is something bad recorded in the profile, then harm is caused to a third party. Okay. Then this data sharing, whether it some of the data can be shared anonymously, all these things become part of the discussions for being compliant. Fine. Now we will come to the discussion on DGPSI principles. Now, DGPSI, of course, stands for Digital Governance and Protection Standard of India. It is an indigenously developed framework specifically designed for the compliance of DPDPA 2023. we have two versions of this. One is called the DGPSI Lite version, which has got 36 model implementation specifications. And there is a DGPSI Full, which is having 50 model implementation specifications. DGPSI Lite takes care of DPDPA 2023 compliance directly, section by section. DGPSI Full includes a lot of governance issues, some of them drawn from the draft BIS guideline on data governance, and also the requirements of ITA 2000, maybe even the Consumer Protection Act and other laws. So DGPSI Full version is actually a combination of many of the compliance requirements. This is supported by FDPPI for implementation and certification, including third-party audit and certification. Okay, we call these implementation specifications as model implementation specification, in the sense that this is the recommended implementation specification. The organization is free to actually make modifications of this based on its own risk assessment and then adopt some of the implementation that is called adapted implementation specifications. So the DGPSI principles more or less work like standards, and these implementation specifications work more like the details of how the principles could be implemented. This is how we have visualized this DGPSI. Now, just as we identify systems associated with the standards like ISMS for ISO 27001, PIMS for 27701, DGPMS is the reference name we use for a system which is built on DGPSI. Now, the objective of this DGPSI is to provide a framework which is compliant to the data protection regulations in India. It should help in implementation. It should help in certifiable audit by a third party. It should also help in making an assessment of the maturity of the compliance, leading to the data trust score. Okay. Now, we feel that this is being made available like an open source because we have placed the entire DGPSI principles details in public space, leaving, of course, the template designing for compliance to the consultants who will be working under this. Okay. So as long as GDPR and other things are concerned, presently DGPSI, if it is applied for the Indian scenario, at the time of classification of data, we are segregating the data to which DPDPA is applicable as the basic set on which we are applying the controls. The rest of it, we are putting it aside, but a similar framework can also be applied for GDPR compliance and other compliances, provided you tweak some of the requirements. For example, when you come to rights management, in DPDPA, we may take certain rights, and in GDPR, we may take some different rights. So if you are willing to actually fine-tune certain parts of the DGPSI, it is possible to have an extension of this framework for other laws also. Now, as far as the audit industry is concerned, we feel that the DGPSI is a one company, one compliance kind of an approach. So that one framework with some minor differences, if it can be made for GDPR, CCPA, as well as DPDPA, it is it will help the organization in making things better. Now, we feel that if there are already auditors of ISO 27001 or other things, they can actually migrate to add this expertise of DGPSI audit as part of their portfolio. That way, they can look at this as an additional business opportunity. Now, today, ISO 27701, if you want to implement, you have got 93 controls of ISO 27001. I understand that this link to ISO 27001 is likely to be removed. Currently, there are these 93 controls of ISO 27001 plus another 49 controls to ISO 27701, are some for controllers, some for processors. I think Ramesh already alluded to that last week. Then ITA 2000, if you want to be compliant, it requires a minimum of around 33 controls under the Indian Information Security Framework. Then if you want to look at the Bureau of Indian Standards compliance, it has got at least 25 what is called as goals for data privacy risk management. So if you add all these things, nearly 200 controls are required to be compliant with different compliances. DPDPA 2023 in comparison requires only 36 in the light version and 50 in implementation of DGPSI full. So it is a substantial reduction of the compliance burden. Then every audit, of course, needs a framework and desired milestones. So that is what we have built here. The framework, which is auditable, and then the DTS system, which we will try to explain tomorrow to provide you some more idea. Now, FDPPI is supporting this, particular certification. FDPPI is not like NIST or ISO. It is, in fact, more like the high trust. It's an industry-based thing. So the question of whether it is government approved and all will be there, but we are looking at the compliance from the management perspective, because all certifications essentially mean that it is due diligence on the part of an organization. No certification will provide immunity against being held liable if things...
Sir, are you sharing your screen?
Yeah, I'm sharing.
It is visible, sir, for us.
Oh, yeah. I did not have. Okay, sorry, sir. Please carry on. I'm not getting it. Okay. I'll check.
So this is just to tell you that FDPPI is not like NIST as a government organization, nor even like ISO, which is an international organization. It has got its own limitations, but maybe we will try to get more of industry approval as we go along. Now, one of the core benefits of DGPSI, which I feel is to be recognized, is that there will be team ownership of the audit program in an organization. Whereas normally ISMS is owned by CISO, PIMS may be owned by a DPO. We feel that even though many of the requirements are common, there is a possibility of conflict when it comes to the implementation. So the system which we are suggesting actually is driven by a governance committee with the respective stakeholders, and DPO is a part of it. And we also use a principle called distributed responsibility for various reasons like that. We feel that DGPMS is jointly owned by business managers and the security or privacy champions. So it is not that if something goes wrong, I will blame the CISO or blame one person called the DPO or somebody else. It is the responsibility of a much broader set of people. Though externally, of course, the DPO is the face that cannot be avoided. Now, the DGPSI, if you look at its scope, it has to cover recognition of obligations of an organization with reference to whether it's a data fiduciary, significant data fiduciary, or a consent manager, whether it's an intermediary, social media intermediary, or significant social media intermediary under ITA 2000. It has to look at application of obligations under Chapter 2 of DPDPA 2023. It has to protect the rights of data principles under Chapter 3. It has to comply with cross-border or local data transfer restrictions, data breach notification requirements, minors data handling, and so on. And this should also enable an organization to understand the exemptions, legitimate use or interest, and designing of compliance systems in according to these details. And we are also trying to add the compliance of ITA 2013 guidelines and including the BIS. Okay, so that is the expected scope of DGPSI. Now, there are 12 principles which we feel are the foundation of this particular system. And if you understand that principle, then probably the rest of the things can be designed as a fallout of this. The first principle, which we have discussed time and again, is that process is the focus of compliance. What we mean by process here is that personal data is being processed by an organization in different departments or divisions. Each of that may have a different purpose. Each of that purpose may require different data elements, different data retention. Therefore, instead of looking at compliance from the organizational point of view and say, I need personal data which has got 23 parameters, I need to keep personal data for 3 years or something like that, we actually look at a given process. For example, say visitors to the website. I don't have to keep that data for more than the session. Okay, if I am looking at it as a service, then let's say KYC, then I don't need to keep all the data beyond the KYC completion. So something like that, we have the ability to define the compliance principles differently, including the data element, so that when I have a database with a row of data which say 23 parameters, all these 23 parameters are not necessarily required to be viewed by an authorized person who by normal role definitions is an authorized person to view the data of an XYZ person. But in our approach, the data access control is not saying that Mr. So-and-so can access the data of Mr. So-and-so. It will also have to say that Mr. So-and-so, for the purpose of a particular process, can access this part of the data store of this particular person. So within the row of data elements, we need to have groups of data, and the groups can be separately allocated to different processes. Therefore, data access control also is to some extent minimized or detailed to the exact purpose which is there. So this is one of the reasons why we feel that this is a better way of working. In fact, we extend it even to the concept of the role of an organization, whether it, instead of saying whether an organization is a significant data fiduciary, I would like to ask the question whether this process is a significant data process equivalent to that of a significant data fiduciary. But for the purpose of law, since lawmakers have not distinguished separately, even if one process becomes a significant data fiduciary process, the organization may still have to look at calling itself a significant data fiduciary. But internally for risk management, I may assign different priorities for different processes based on whether something is a critical process, something is a significant process, something is an ordinary process. In fact, tomorrow when the government decides about data transfer, that is cross-border data transfer, it may so happen that one of my processes may have a critical process and I may not be able to transfer the data output from that process abroad. Whereas in other processes, I may be able to transfer. So I will be able to even look at this cross-border data transfer restrictions individually to different processes. So these are the advantages which we feel. And so we structure the organization as an aggregation of multiple processes. Wherever personal data is being processed, we identify that as a unit and then work around that. It also helps me in identifying a process owner, and the process owner has got good visibility on what is happening within this process. Therefore, I can rely upon his assessment about the risks associated with the process. So when I do a risk assessment, I will pick up the risk perception from the process owner himself, because anybody outside that process may not know what kind of things are going on within the process. So there are so many advantages. It actually brings the management of compliance to a micro level instead of talking big about an organization which may have 50,000 employees spread over 10 locations and expecting that the DPO will be able to handle all that these things. Okay, so that is one of the principles. The second principle, which also we have discussed in fair detail, is the classification. Classification is the key, and the classification of data should follow what is required for compliance. So whatever is required in the law for compliance, if there is a different law for employees and employers and the public data, then my classification has to be that employees data is one classification, public data is another classification. If the law is different for say minors and adults, then I have to have that classification. So classification has to closely monitor what is the law related to a particular thing. If some particular exemption is there, and that exemption is to a particular context, like we said that say minors data processing is permitted by, let us say, school bus owner, okay, school bus driver or somebody, okay, who is taking the children to the school and other things. Now, the data of that particular category has to be classified differently, because the controls which are required for handling that process. See, here is a separate process. The process is that the students' personal data is processed for the purpose of fetching them from their residence and bringing them to the school. Now, this information is available. One of the data access person is the driver, or say the when a school representative who accompanies that. They know the residents. They drop this student at the particular place. They pick up from a particular place. If the parent is not there to receive, they will wait for the parent to come, which means that they know who are their parents. They have the pictures of the parents. So this sharing of data to the controller of the bus and the driver is for that purpose of fetching them for that particular purpose. So in that process, what is the information which is to be given? These people did not know what is the profession of this parent or something like that. So the whole database of this particular school, the student may have those details, but these people will have only 2 or 3 elements. Like that, it is part of that process, and then classification also will be that data which is required for this particular purpose, which is exempt from a particular section, I put it as a separate class. It becomes easy for me because I can put separate controls. So every provision of the Data Protection Act which requires a data to be handled in a particular manner, I look at it as a class of data. This is the reason why we have not 1, 2, 3, or 4 classes of data. We have 31 classes of data for the purpose of compliance under DGPSI system. In fact, most of the complications we are building at the time of classification itself, so that once it is classified, you know that this is the control required for this. This is the data to be given to the driver. Yes, this class of data can go to the driver. If tomorrow, if this attendant is changed and some other attendant comes, so automatically that person will have access to this particular set of data like that. Okay, so that is why classification follows the section on which compliance is required. The detailed list is available in the DGPSI booklet, and I think we discussed this also on the other day when we looked at the classification. Now, having looked at this process and classification, basically we are looking at the organization as a hybrid entity. And some processors have sensitive processing, some process may have less sensitive processing. So there is a combination of a character of a significant data fiduciary, non-significant data fiduciary. Somewhere the organization is only a data processor. So we are looking at the organization under this hybrid entity concept. Okay. Then the important criteria is the distributed responsibility, which is to say that every person in the organization who has got access to data is responsible for the protection within his environment. I cannot say that I will have access to data, but DPO is responsible to know whether I am using it properly or not. Okay, that principle we don't think is the correct. So if I have got an access to certain kind of data, I am responsible for that. Again, taking the same example, if I am the bus conductor and I am having some data, I am the person responsible for that data to be secured. If it is there on my mobile, and I have got the list of students, their residence number, the pickup point, and other these things, that data cannot go out of my control, and I cannot blame the DPO. DPO at best may tell you that this is sensitive data, you should hold it properly, but he cannot know whether you are sharing that in a WhatsApp group or you are helping the parents to create a WhatsApp group of all the people who are coming in that particular bus or something like that. So that much of understanding has to be there to that local data controller. You may call them as an internal data controller or the process controller or something like that. So that is the distributed responsibility system. One DPO is not going to be holding all the responsibilities. There are lots of sub DPOs, and above the DPO, there is a governance committee which has got the stakeholders from marketing, stakeholders from HR, stakeholders from the finance. These are the persons who normally create problems for the DPO. Even the R&D persons. Okay, the R&D person may find something new. Now, of course, we are in the era of AI. They may do so many things and they may get excited and push the CEO to accept some processes. DPO always has a challenge about adoption of new technology. He will insist on the DPIA. So therefore, we are saying that above the DPO, there is a governance committee. Below the DPO, there are process controllers, and all of them help share the responsibility. That is the distributed responsibility. The principle number 5 is that data has got a monetary value. We will never forget that data has got a money value, and that money value has to be recognized. In fact, if you don't know what is the value, we don't know how much of resources we can provide for the particular purpose. Of course, valuation of data is an entirely different problem. Chartered accountants have to sit that. Currently, data in the industry, we adopt different kinds of processes. Somewhere we use market value as per market marketability of a particular commodity. If it's a finished goods, I will take the market value. If it is data, inventory in process, I may take the raw material value or may add some process value. There are various ways by which industries actually value their inventory. And there are also cases like in the diamond industry and other things, there is a revaluation system where as every year before the balance sheet, I will revalue the assets. There is no depreciation or appreciation. It has to be valued at that point of time. Whereas machineries, we take the asset value and then depreciate it. So there are so many systems in place. Intangible assets, we have a different system. So data has got its own system. Our data valuation standard of India tries to address this issue. The identification of this value has got a lot of implications on data retention. See, we were discussing about the legacy data, and what if I don't get back the response? I said that we will purge that data. So your marketing person will say that, no, we cannot delete any data. We have taken so much of effort to collect that data. But remember that if the data is old, let us say 2 years, 3 years, 5 years, the value of that data has already got depreciated. That person is no longer your marketing prospect. He was perhaps a marketing prospect 5 years back. Now, today he may not be so. He may either not be existing or his preferences would have changed. He was perhaps using at that time Colgate toothpaste. Now he will not touch Colgate toothpaste. He may go for Baba Ramdev's toothpaste. We do not know. The preferences also may change. So the value of data, personal data, varies with the time of its retention. And unlike you say old wine is more valuable, data, when it becomes old, it actually, personal data loses its value. Its address is no longer correct. Street name would have been changed. So many things would have happened. His educational qualification would have changed. So everywhere data loses value with the efflux of time. Unless you recognize this, you will not accept that, okay, beyond 5 years, if I'm not processing that data, it is just lying there in the data store. What is the need for having that? Let us purge it. At least we'll perhaps open out some storage space. So that is the reason why we feel that having a monetary value identification is important. It will help us in the data breach risk assessment, and maybe in several other areas, including, of course, seeking more budget for managing. Sixth principle is that the compliance system should be measurable, in the sense that I have to be able to find out or assess how good is my compliance system. Okay, so this is what leads to our data trust score system. Data trust score is possible if your implementation is done in such a manner that you are able to measure it. Of course, measuring the compliance maturity is involving the legal aspects, the technology aspects, some of which are very subjective. Converting it into objective form is very tough, but still we need to do that. In fact, when we go to the DTS, we have actually recognized 5 different responsibility centers. We give different weightages to different responsibility centers, and then we aggregate them. The idea behind that, it may not be perfect as of today. We hope we will be able to improve it as we go along, but the principles are already there, that in assessing, we need to actually look at a mechanism where compliance should be in some way measured. Then principle number 7, critics of a company are the early whistleblowers. We expect that the whistleblower system is a very important part of incident recognition system. Okay, it is, of course, sometimes used as a bug bounty program or something like that. But from my incident recognition system, perhaps the first indication of there is something wrong in my company comes from a customer complaint, which he may not be our employee. Sometimes he may be an outside vendor, but somewhere from out of the complaints which we receive, we may identify that there could be an underlying problem. So recognizing this and building a whistleblower policy which incentivizes recognition of such complaints and also protects the whistleblowers is an important aspect, and it should not be restricted to only the complaints about other employees and other things. The whistleblowers policy should also extend to even the bug bounty program. After all, I am giving the incentive for a bug being reported to me. In a way, that person is doing his whistleblowing work by saying that your software has got some kind of a bug. Now, principle number 8 is top management should take the responsibility. Therefore, after the initial risk assessment, we are trying to say that if you want to make changes, there has to be a deviation justification document, and the top management has to sign it off, and then only the implementation charter will be rolled out for the purpose of the team to implement. In fact, when we do the audit, audit is done with a reference frame of these adapted implementation specifications. Adapted specifications are the one which is model implementation specification as modified by the deviation justification document. Now, whatever the deviation justification document is signed off by the management, the risks arising out of that, they are approving the risk absorption, so that the DPO will not be tomorrow held to accountability, because in the initial gap report based on the model implementation specifications, he would have provided that risk assessment, which the management has decided to make some change. Now, principle number 9 is that the compliance should be integrated with new business acquisition, pricing of services, business acceptance, processor selection, buying of hardware and software, selection of manpower, all these things, which is DPDPA compliance is not a responsibility of only the compliance officer, only the DPO, only the CISO or something like that. The entire business is involved, and the implementation will start from the marketing department, which goes for a new business acquisition, CFO who suggests certain pricing of the services, and so on. So that is the reason why our committee is supposed to have representatives from all these sections. Key principle number 10, documentation, of course, is integral to compliance, and being a legal compliance, the emphasis on documentation has to be high. There is, of course, the key principle of security, which is the CIA concept, and that is to be applied to personal data. So that is there. Then the normal CIA principle, even if you augment it with assurance and non-repudiability, is not sufficient. It is necessary, but not sufficient, because we have to add principles of legal basis, etc. That is why when we talk of data security under DPDPA is bigger and larger than data security under the ISMS system. That is the reason why we say that the DPO is actually a bigger and more responsible position, and he has to know whatever CISO knows, but he should also know something about law. So this is this expertise required to be a DPO is something bigger. Now, the last principle which I would like to reiterate, which all of you are aware also, is that motivation of people is fundamental to any policy implementation. There is no point in having all the technology or having all the policies unless we are able to understand that everything has to be implemented by people. Therefore, developing a culture of compliance with awareness along with acceptance. Okay. See, there is no point in just having training programs. Everybody is aware of DPDPA, but there has to be an ethical acceptance of that. So that's why we say that ethical declaration has to be signed by every employee, in which he will make a commitment that he knows something about DPDPA as was given in the training program, but he will take his own efforts to learn more on his own. Does not tomorrow come up with an excuse that you did not give me the training, so I did not know. It is the responsibility of every employee to learn about DPDPA, and it goes with the distributed responsibility principle also. And he has to be motivated. Motivation can be through positive motivation with incentives. It will also be through sanctions or say disciplinary proceedings. Both are required. So using all the motivational strategies, and also give him appropriate tools and other things, you ensure that the privacy culture is available across the organization. That's why training becomes a very important aspect of compliance here. See, these 12 principles are important for us to remember. Once you adopt this with classification, the temptation is, of course, to do some automation, but automation has to be supervised by humans, otherwise there will be an issue. So this is what I wanted to talk today as DGPSI principles. Under these principles, how we have generated the DGPSI light version and full version, we will discuss tomorrow. Okay? Any questions?
Trust score. So we spoke about the trust score. Is
Yeah.
the continuous monitoring also is part of the trust score that we implement, sir, or that needs to be looked into separately?
Say right now, the data trust score comes out of an audit. Okay. Now, if there is a concurrent audit on an organization, you can concurrently modify the DTS also. But external auditor giving the DTS is one. Internally, we may have to create a dashboard. And in the dashboard, you start the period of audit with the previous external auditor who has given a certain DTS. Then you may have to monitor changes which has happened in the processes. We have got say 10 or 12 processes. For each process, we have made assessments. So whenever a change happens in that process, it will have its impact on the DTS. So if the DPO can make some corrections, you can actually monitor the DTS on a concurrent audit basis also. And you again revalidate it from an external auditor at the end of the period. That is how perhaps you can construct.
Okay, sure. That makes sense.
Yeah. Anything else?
Can a DPO facilitate in the business teams handling the personal data in determining the DTS scope?
See, ultimately, the person who has to do the internal audit and come up with his own assessment of DTS will be the DPO. Okay. Now, but significant data fiduciaries have to do external audit at least once in a year. So obviously, the assessment will be better when an external auditor comes, because even the bias of the data protection officer will be corrected because the person is an external person. So within the organization, DPO is the person who is having the least bias in terms of business interests of the marketing person, the R&D enthusiasm kind of a thing. DPO can take a stand which he is the best person to come up with the DTS internally. But his DTS is again internal DTS, and an external person making an assessment may come up with some disagreements with the DTS and then give his own assessment also. Because we are all talking of a subjective assessment being converted into an objective number. DTS is a number. Now, if I say that the privacy notice has to be transparent, should be easy to understand. Now, to assign a score for that, whether it should be 3, 4, 5, 8, 10, is a conversion of a subjective thing into an objective aspect, which is tough. So that is why there could be some disagreements, but internally, the DPO is the person who can have the DTS, and externally, data auditor will come in. Okay, same system can be used, but the assessor may be different.
So the DPO, being a neutral person, can decide on the score,
yes.
But it needs to be concurred with the business, the respective business and the process owners as well, correct?
Oh, see, they may not agree. That is different. Okay. Say, if you look for concurrence, then you are compromising your scoring. Okay. So because the marketing person will always say, I will first get the contract. Don't ask me this DPO issues and other things. You manage the technology in a way, particular this thing. I don't want to delete the data even if it is 5 years old, because I have spent effort on that. So that is the stand which the marketing person will take. Okay. So don't look for concurrence. You share your DTS score, and when we look at that, you will see the 5 responsibility centers. Management is one, DPO is one, legal is one, and HR is one, and IT is the 5th one. So suppose I get a low score on IT, I will challenge that IT person to improve it. Okay, he has to satisfy me that whatever measures he has put in is good enough. Similarly, the legal person and others, they may not concur entirely with me because they think that I know better. See, but that is something which you have to handle and leave it to the external auditor to either agree with you or agree with the departmental person.
Okay, thanks.